Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neideigh. I'm here with my friend Omar the Tilted Lawyer and my friends Bruce from Oregon and Schnitzel Ninja. You guys have probably, if you've been watching for a while, seen all of them here at some point. But I gathered everyone here tonight because I cannot bear to read my own filing in this case. So I'm going to have some friends do it for me.
Oh, God.
Yeah. Oh, God, exactly, dude. I was thinking, I was like, should I have Omar on here? He might hate it. But
I mean, I pre-approved it, so sort
did
of.
you? I didn't know if you had time. So I was kind of like, all right, whatever.
Well, I read it, I scanned it in 30 seconds, like, yeah, do that. I was like, file it. This thing is great.
I mean, that's about my approach to things these days. So I think that's solid advice. Anyways, I wanted to mention some people in the chat were saying as well, before we get started, that tag list, a list of people who were in communications with the agency group.
Has it grown?
And that was the dispute. The agency group was a former crisis PR group that worked for Justin Baldoni at some point for a little bit during or after the immediate aftermath of the film marketing and like when all that drama stuff was going down.
Yeah.
And they implied, Blake and her counsel implied, that we were all on a list that they disclosed in Discovery. That we worked at the behest of Wayfair to produce content that was negative about Blake Lively. What actually happened, as we learned either yesterday or the day before, was there was one person from the social media subpoenas that was identified on that list, and that was somebody who made a routine request for comment, as somebody from the media does. It was a larger YouTube channel. It's not a weird thing to do. And that I happen to know for a fact that that is somebody who has asked for comment or participation at some point between all parties. So it's not just the Wayfair parties. So. And today that was finally unsealed because that was an attorney's eyes only provision. I guess that list of content creators that tag had been in contact with. And as the Wayfair parties said, there was one name, that person I just mentioned, on that list. Just of people who had communicated with them, aka asked for comment. And people have been kind of trying to burn a lot of us at the stake because there is 45 content creators or journalists or whatever you want to call it at some point in the last week or so that have been implicated in this imaginary smear campaign. And there was one person from the social media subpoenas that was listed in those disclosures. So that was intentional. It was an intentional misrepresentation of the facts, I felt like. To make us look bad, to implicate us in this smear campaign. And this is the first time I've ever been on the weird receiving end of a conspiracy theory. And I'm just kind of like, I've never talked to TAG. I've never talked to any publicist involved in this lawsuit. And today kind of confirmed that, which is interesting because now I'm seeing what it's really like when conspiracy theorists are confronted with the facts. And it's a hard cope. So I'm I'm on the receiving end of some weird theories right now, but I gotta tell you, it feels a little good to be.
So what would you
say
you learned here?
I mean, just be careful with the way that lawyers word things, I guess.
Lawyers are dicks. I think that's like the overarching lesson.
You say that a lot, and the thing is, like, the people that I have in my life who are attorneys, and that's a lot of my closest friends. Like, you're one of my closest friends, and then I have people in my personal life that they're not YouTube people, so I don't really talk about them, but they're attorneys, and they would never do what these people are doing. So attorneys are dicks, yeah, but some of them aren't, you know?
Yeah, some of them aren't, but the ones that are not, you don't hear about those. The ones that you deal with, the ones that you have to oppose, the ones that you have to litigate against. Those
are the only ones that I give a shit about.
And those are all dicks. And then the best of luck.
I'm saying the only ones that I care about are not dicks. They're really great people. So.
Well, I erased what I said.
So Lauren, I have two questions for you.
Yeah, what's up?
If you're ready.
Yeah, go ahead.
Number one, did they send subpoena? So this list is now, you've seen this list of the list that only had one person, you know. Okay.
Right.
Did they send subpoenas to the other people in that list?
So the list of the 4 people they identified, it was Perez Hilton, which they did subpoena Perez. Andy Signor is the one that was identified, and Popcorn Planet. He did the documentary. He's been totally transparent about this. He was one of them. Candace Owens was the third, and fourth was Billy Bush. So 3 out of the 4 of those received individual subpoenas directed to them. But Andy happened to be the only person who got a regular subpoena served to him, as well as the Google subpoena. So she made it sound like people in the social media subpoenas, as they're calling it, were on the tag list, when really it was just Andy who got a routine request for comment.
So my two questions are, why didn't all the people on the tag list get subpoenas? It sounds like only 4 did. That's number one.
Right.
And number two, where did you come from? Like, are you on some list? Like, why did they do these social media subpoenas? That's my second question. Like, where did you guys all come from?
We came from nowhere. The thing that we have in common is that we have all spoken negatively or unfavorably, or in some way just like talked about Blake Lively in a way that she didn't like in this litigation, or in the immediate, kind of preamble, I guess, leading up to this. So that is the only common denominator.
So here's my conclusion, and tell me if I'm right. They had a list of like 60 people, and they subpoenaed 4 of those.
42. No, 43, sorry. And then plus Candace and Perez is 45 if you include the
So they had some big tag list, and they subpoenaed only 4 of those people. And didn't subpoena the rest.
Let me pull up the tag list, because...
Is that correct?
It'll make sense. Hang on.
I have maybe a little lag, so sorry.
They have... No, you're good. You're good. They have a list of people on here. But when they were asked about content creators, there were only 4, I believe. But we're going to find out real quick.
Okay, so Tag had a list of 60 contacts or 40 contacts or whatever, but they only sent subpoenas to 4 of those people, correct?
3. Of the contacts on that list, they sent them to 3, but only 1 of the people from the social media subpoenas was on there.
Right.
And that was
then the other subpoenas they sent out weren't on any lists that anybody's identified. Is that correct?
Correct. Yep.
So this is very strange.
But they implied that we were, and that was intentional. It was a really bad PR move, because they thought that Wayfair and Tag, because the client list or the contact list for public relations firms, as they established in the very beginning of this case, that's protected information. It's attorney's eyes only. They thought that they would fight that. And Wayfair said, no, fuck that. We want to disprove their allegations that there's some kind of smear campaign with content creators, so we're just going to let it be unsealed.
No, I get all that. I'm asking subsequent questions like...
No, I was more saying that for like people who are, watching, but...
Oh, yeah, for sure. And based on that, what can we learn? It seems very strange that they would have a larger list and make a few subpoenas from that list, and then subpoena a bunch of people that weren't even on any lists.
Yeah. Give me 1 second.
It's very odd.
I have to go back in the docket here. 51 or something. Yeah. So, here we go. That's not it. Hang on. Share this tab. Okay, so here's the tag list. And I think it is number 5 that we're supposed to be looking at, but we'll look at all of them just in case. Yeah, no, it's response to interrogatory number 5. Okay, responding party incorporates by reference its general objections, blah, 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 blah. So they're saying it's like overbroad. They don't, on the grounds that it's vague about communicated, because people are saying communicated means worked at the behest of, basically. But the actual list of people is right here. It's 4 people: Billy Bush, Andy Signor, Candace Owens, and Perez Hilton. So, and she implied that all 45 of us were on this list, and we.
How on the basis of that do they send you a subpoena?
That's what they're saying. The basis was,
That's what I'm trying to get to, Omar. Like, so there's not even a list of like 60 people or 45 people or anything. No. There's a list of 4.
And that's it.
It was a last ditch PR attempt.
They subpoenaed 3 of these 4. Yeah. Is that true? 3 of these 4 got subpoenas. And Andy,
as far as we know, Billy Bush has not been subpoenaed. Yeah. So
Andy gets the 2-for-1. He gets twin subpoena. He gets the twins.
Not the twins.
And then okay. And then we don't know where the rest of you came from. Cassidy and you and everybody and Lee.
Bitterness.
We know exactly where we came from. It's people who don't believe Miss Lively was sexually harassed by Mr. Baldoni.
Oh my gosh. This is unbelievable.
It's like Omar, she can't possibly believe that people don't believe her or people don't like her.
Correct.
Well, I'm just curious about all the I don't know what you would want to call it, misrepresentation or miscommunication. Have you ever seen this kind of thing, Omar, where it's like, here's a list of 4 people, and then 42 subpoenas go out?
Well, I've gotten subpoenas like that, and I would tell them to kiss my ass. I ain't complying with shit. If you don't withdraw it, I'm going to do a motion to quash and ask for sanctions. Fuck off.
Can you imagine if that's all your motion to quash said?
It's literally what I did. And then they just removed it. It's like, yeah, that's okay. And then we just whittled it down. And they came to their senses because it's stupid. Like, you give me an offer of proof why you need a subpoena. This has nothing to do with the case. And then, I would threaten them with a motion to quash and sanctions, or they could just withdraw it and, try again. And they just withdrew it. It was fine.
Well, I mean, I asked for the offer of proof. And then at that point, they were like, okay, we can meet and confer at your convenience. So I told them, and I'm not going to talk too much about the meet and confer process, but I will talk about the evasiveness because I already wrote it in the filing. I was like, okay, my convenience basically is what I said. I didn't say it like that, but my convenience is like, I have these days available this week. And I told them what time zone I was in, like they asked. And then they refused to respond for like a week. And then so I sent a follow-up with the same questions that I was like, hey, you still haven't answered these questions. And basically I was thinking, like, in light of the tag interrogatories that we now have more information about, why are you choosing to subpoena my information? Other than I have, expressed my, my protective or lawful free speech to say unfavorable things about Miss Lively. No real answer until like late last night. I didn't even see it because I was so busy working on this stuff. And then early this morning, I turned it in. And then I get another email from them, I guess, a little bit after that, where they're like, we saw you filed a motion to quash. Like, we want to meet and confer. And I said, okay, well, I'm working until 6 today, so I can't really do that. It's a little bit late, maybe Monday. They wrote back, we can meet at 6. And I was like, dude, when I say 6, I mean, I work to 6:30. So I said, Monday is better for me. What time? And then, of course, they stopped responding again. So I don't know what the deal with that is. People are saying, like, don't meet and confer with him. No, I'll do it.
I think it's required that you got to at least make the attempt. But the fact is, you also have a deadline.
I do not. They do.
Yeah. So. You have a deadline. And so if they're just going to play games, then you proceed. I mean,
I don't have a deadline anymore. It's already done. So.
Oh, well, how about that?
Gosh.
Yeah. All right.
Omar, shouldn't they have done a meet and confer activity prior to filing a subpoena?
If you're going to file a subpoena, no. But
No?
I would assume they would at least have an offer of proof to issue the subpoena. And if they do, then they don't need to ask anyone's permission. They could just subpoena somebody. What they can do is meet and confer after it's already been issued, and either just tell them, have a conversation. Look, this is all I'm looking for. If you give me this, I'll withdraw the subpoena. This is all I need to see. Or comply with the subpoena, whatever. Why? Because I've connected the dots because something, and I need this information. They're not doing that though. And they misrepresented that they may have based this off of discovery responses received from the Wayfarer parties. Turns out that's a load of horse shit. And so unless they could tether some other kind of offer of proof to all of the other subpoenas that are not from the 3 named on that list, then these are easy motions to quash. I don't suspect that the judge is going to allow this to stand. I just don't.
So your process is an offer of proof, then a subpoena, then if there's questions from either side, you have a meet and confer. Is that the correct?
Well, the correct way to go about it is, like, they've done discovery, and so they get a list, and they're concerned about smear campaigns. Great. Give me every content creator information that you've communicated with about this case since such and such date, whatever. Then you take that list and you subpoena those people. What you don't do is just start subpoenaing people at random that you have no basis to subpoena. That's inefficient. Right. At best, it's inefficient. And so they're kind of going about it backwards. I'm just going to subpoena 60 content creators at random on the suspicion that they may have had communications with Wayfarer. No, man, you're allowed to fish. You're not allowed to fish like that. There's a much less intrusive way to do it, and which is the way that I suggested.
Yeah. So the correct process here, if TAG gives them this list of 4 names, they should file 4 subpoenas.
Yeah.
Because and then if there's questions about those subpoenas, then you have a meet and confer process.
Right. Exactly. Like, if you got a basis to subpoena something, just issue it. Like, why waste time? It's easy to withdraw. It's easy to meet and confer, but it puts them on notice that you're looking for something. What I won't do is just start abusing the subpoena process, which is what they appear to be doing.
Mm-hmm. All right.
Thank you.
So we'll get into the, I'm not going to read that first part. Hang on. But we'll get into the memorandum here. But I'm going to have Snitzel Ninja read most of this because I cannot read my own fucking filing. It's embarrassing to me. People say that like when content creators get dragged into this, they call it like legal warfare, or like litigation warfare or whatever. I don't know what they call it on YouTube. You're supposed to make content out of it and like make money and stuff. I'm just like, I'm so uncomfortable reading my own shit. Like I can't help it. So like I was like, I need friends. So
I'm not uncomfortable reading my own stuff.
I know, but that's because you're a lawyer and you have to do that. So
yeah, I like the sound of my own voice. I like the sound of my written words as they're read on a page.
I mean, I don't not like your voice or your written words. I'm just saying mine are a problem for me. So I'm going to be in the live chat, but I'm going to have, like I said, Snitzel Ninja read most of this. If you want to stop and talk about it, you can ask me questions and I will answer them. Otherwise, I'm just going to be talking to the people who are watching, and I will be the scroll bitch like I was before.
Oh, God.
All right. So we'll start here.
Pages, Jesus, Lauren.
Most is like the 30 pages of subpoena.
Oh, the
so we're not gonna,
okay.
Yeah, we're not gonna have to worry about that. All right, let's. You want to start here, Snitzel at the top?
Please take notice. Okay. Please take notice that non-party Lauren Neideigh Movin respectfully submits this memorandum of law in support of her motion to quash the subpoena issued by plaintiff Blake Lively to Google LLC, commanding the production of certain documents. The subpoena dated July 3rd, 2025, internal reference number 100884180, seeks personally identifiable information and private data associated with Movement's YouTube account at Lethal Lauren 904. Additionally, Movement respectfully seeks issuance of a protective order barring further abusive discovery by Ms. Lively without prior court approval. Introduction. This motion to quash the subpoena refers to the subpoena served on Google LLC seeking private information and data of 16 YouTube creators under the premise that they are engaged in a smear campaign against plaintiff Blake Lively at the behest of the Wayfarer parties. Exhibit A, the subpoena, targets creators who have expressed unfavorable opinions about Ms. Lively online. The subpoena is not supported by any evidence. It serves to intimidate, harass, chill constitutionally protected free speech, and threaten the safety and privacy of non-parties who are not involved in this litigation. Ms. Lively has offered no reasonable explanation for why she believes Movement's criticism of her is inorganic. Counsel has been uncooperative or unresponsive upon Movement's attempts to meet and confer. Ms. Lively's counsel would only state that Ms. Lively brings claims against the Wayfarer parties in part on the basis that they engaged in a digital media smear campaign by planting negative stories about her in the press after she reported sexual harassment on the film It Ends With Us.
That is all they ever told me before I filed this, by the way.
That's crazy. Ms. Lively has issued subpoenas seeking information about accounts that posted such information or otherwise engaged with that content to determine whether the Wayfarer parties played any role in its dissemination. Exhibit C. Movement attempted to confer to determine how her personal information and private data could possibly fit into Ms. Lively's smear campaign apologue, given that Movement did not even begin discussing Ms. Lively's case until after the lawsuits were filed, and Movement's coverage of this case relies upon publicly available court filings or public information that has already been disseminated by legacy media outlets. Ms. Lively's counsel ceased responding upon requests for further explanation. Thus, the subpoena appears nonsensical. For example, it is unclear how Movement's backup email addresses and login history could have contributed to Ms. Lively's turmoil over the public's negative response to her decision to hawk alcohol and hair care products while promoting a film about domestic violence. There is no reasonable connection between Movement's login history, the Wayfarer parties, and Ms. Lively's public relations plight. Ms. Lively is unable to explain why Movement's private personal information and data are relevant to the litigation at hand.
Hey, folks, I hate to do this. I got to run.
All right.
My sincerest apologies. I'll catch you all later. Have a good weekend.
Bye.
All
You
right.
too.
Have a good one.
This attempted excavation of private information and data and refusal to cooperate in meet and confer efforts is an abuse of the federal government as a mechanism to confuse, embarrass, and punish lawful expression of unfavorable opinions of Miss Lively by private citizens who cannot afford to hire counsel to entertain Miss Lively